Well, hello and welcome to our video. My name is John Watts. I'm a consumer protection attorney in the state of Alabama. And what I'd like to do in this video is answer a number of questions. Over the last several months, we've received literally hundreds of questions. And I want to start doing some videos and we'll just kind of work our way through these questions. And so like I said, we'll answer about 7 today. And if you have any questions you'd like us to answer, you can either leave us a comment on a YouTube video or go to alabamaconsumer.com, or you can call us at 205-879-2447. And the last thing I'll say before we get started is, well, maybe two things. Number one, I'm sitting outside, so if a plane flies overhead or a dog barks, we'll just try to push through that. I'm enjoying the nice weather we're having. The other thing is I'll answer all of these based upon the questioner being in Alabama. So if you're in a different state, you need to get with a lawyer in your state to find out if it's the same answer or not. Regardless of where you are, you need to get with a lawyer, go over your specific details. Here are all my details. Here's all the facts. And then let that lawyer give you specific advice. This is not legal advice I'm giving you. I'm just trying to give you some general thoughts, general ideas, so that as you start your journey to figure out the answer to your particular question, maybe this will give you a little bit of a head start. So we'll go ahead and start with our very first question. And this is a lady, she says she and her ex-husband purchased a car in 2002. They were divorced. He had the car. It was then repossessed in 2003, and now she's having some type of lawyer, I assume a collection lawyer, sending notices to her place of employment. And so the question is, what in the world do I do? Well, first thing is, let's start kind of at the beginning and then we'll work our way forward. So on a typical car loan where you go and buy it from the dealership and the dealership puts down their name as the seller, they put down the terms of the financing, then that typically is going to be a 4-year statute of limitation. But then the question comes up, well, 4 years from when? Well, typically from when you stop paying. And the easy date is usually the date of repossession. And so we start there and then we go 4 years forward, assuming there have been no payments. Then once you get beyond 4 years, then that's typically too long to file suit. So if they took out the loan in 2002, is repossessed 2003, that means we're looking at suit should have been filed in 2007. Now, she's getting these notices to her work. Well, a couple possibilities. One, she was sued before 2007 or even after 2007, and there's a judgment against her. And if there's a judgment against you, then the company that has that judgment has many, many years to collect it. So that'd be the first step is, was there a lawsuit filed? Was there a judgment against us? If there was a judgment, then we need to know, were we served? In other words, did we get the lawsuit papers? Because if we weren't properly served, then we can attack that judgment to knock that out. But if we were served, and even if we had a great statute of limitation defense, but we did not assert it. In other words, we get served with the lawsuit and we just don't do anything, then it's too late to raise that statute of limitation defense. So either we were sued and somebody got a judgment against us, and that's why they're approaching our employer to find out, well, do you work here? How much do you make? And that's to do garnishment, which is usually 25% of our take-home pay. So either we were sued or some company, a collection law firm, whoever it is just reaching out to our employer on a debt they cannot sue us on. And if that's the case, then they're going to have some very serious problems with that. Typically, they cannot reach out to an employer except to simply find out, do we work there? And that's only if they don't already know that. So there's something called location information. That's home address, home phone, place of employment. A debt collector can contact somebody other than us or our spouse to get home address, home phone, place of employment, but nothing else. And typically when they contact an employer, they're saying, what's your position? How long has this person been working here? How much do they make? Who's their supervisor? way beyond what the law, the Fair Debt Collection Practices Act, allows. So we just need to know, is there a judgment? Is there not a judgment? And why is this collection law firm or somebody pretending to be a collection lawyer contacting your employer? So bottom line is, we got some questions to answer, but quite likely something wrong has happened here. And we should be able to do something about that. So I hope that that's helpful. Now our next question is, I've got a collector calling my mother's neighbors 3 to 4 times a week, and no surprise, neighbors are upset. How do I stop this? Well, if you saw the previous part of this video, there's something called location information under the FDCPA, or Fair Debt Collection Practices Act. Location information is a debt collector can contact what's called a third party. So a third party is just somebody other than you or your spouse. So a neighbor would be a third party. They can contact third party and say, I need home address, home phone, place of employment. Now they can only do that if they don't have that information. If they already have that information, they have no reason to call your neighbor. Now, if they call and neighbor says, look, here's the information, or I'm not going to give you the information, don't call back again, then they don't need to call that same neighbor again. And if they already have the location information, then calling any neighbor would be illegal. So that would be the first step we look at. We say, why is this debt collector calling? Now, I'll give you the typical reason. It's because when they call your neighbors, it's very embarrassing. Your neighbors see you, they kind of holler across, hey, somebody's calling you, or they come knock on your door. Very, very embarrassing. It harasses the neighbors, and then the neighbors come to you because they're bothered by this. Or in this situation, they go to the daughter of this person who supposedly owes money, and they say, look, somebody keeps calling me, I need you to stop it. Well, if we have a debt collector breaking the law, and when they're calling neighbors, I'm going to say 95% of the time they are breaking the law, then the solution is we sue that debt collector under the FDCPA, the Fair Debt Collection Practices Act. Now they have to start paying money damages, they have to pay their attorneys, they have to pay your attorney, and that shuts them down very quickly because they get it through their brain. They go, oh yeah, maybe I shouldn't be breaking the law, because it becomes very expensive to break the law. So if you're in this situation, just get a notepad, get your phone, whatever you need, start writing down who's calling. Ask the neighbor what phone numbers. They may can look on their cell phone, their home phone, get your caller ID. There may be a voicemail, but find out who's calling, what phone numbers, when did they call, and then talk to a lawyer. If you're in Alabama, you can certainly give us a call, 205-879-2447. And let's look at that situation. If it's legal, if it's proper, then we'll talk to you about here's what you do next. But if it's illegal, and it almost always is when we're dealing with collectors calling neighbors, particularly in this particular question, I think it was 3 or 4 times a week. I mean, that's just crazy. That's like 99.9% illegal. Then normally the best solution is you sue these guys under the FDCPA, Fair Debt Collection Practices Act, and once they have to start paying out money, then they suddenly go, whoa, we want to leave you alone. We'll never bother you again. So that can be a great solution to it. Okay, so our next question is, I was laid off and a neighbor was approached by a man who was saying that he wanted to talk to me and find me because I'm being sued. And so the person asking questions, what do I do? How do I stop this? Well, basically 2 possibilities. One is this is a debt collector. It'd be pretty unusual to be doing that in person, but it's possible. If it's a debt collector saying to your neighbor, hey, I need to find somebody because they've been sued, that's going to be illegal. So we would sue that debt collector under the FDCPA, Fair Debt Collection Practices Act. More likely, though, this is what's known as a process server. This is somebody, they've got the lawsuit papers, and they need to hand these to you so that you will be served. Because once you're served, the clock starts running to file an answer. If small claims are district court, you have 14 days. Circuit court, you have 30 days. Now, if it's a process server and all they say is, hey, say they go to one of my neighbors, hey, I'm trying to find John Watts, I've got some lawsuit papers to serve. It's annoying. It's not really what they should say, but it's probably not illegal under the Fair Debt Collection Practices Act. Now, if they say to a neighbor, hey, I'm trying to collect this debt, I'm trying to get some money, also I have these lawsuit papers, now that's going to be illegal. So we would need to figure out who this person is. The simple way to figure this out is, assuming that you live in Alabama, give us a call, 205-879-2447. We'll just look it up on the computer. Put in your name, where you live. Let's see, is there a lawsuit against you? Now, if there is, then we need to deal with that. We need to know, does the court believe that you've been served or you haven't been served? But if there's no lawsuit against you, then we'd start wondering, okay, well, who in the world was this? Maybe they gave a card to your neighbor. Maybe they gave a phone number to your neighbor. And so that can help us track that down. Because if you haven't been sued and this is a debt collector doing this, then we're going to be very interested in potentially suing that debt collector under the FDCPA. So as I mentioned, I'm outside here on my patio and there's a plane overhead. So hopefully you can still hear me with this. All right, so our next question is, now this is a little bit of a twist on our other questions. This is the neighbor asking this. A debt collector called me looking for a neighbor, and then they asked me to give a message. Is that legal? Okay, so let's make sure we got everything straight. So imagine that I'm the person getting the call, and they're not collecting against me, but the debt collector's calling me saying, hey, John, I need your neighbor across the street or down the road. And the question is, what can I as the neighbor do? Well, here's a general rule. If it's one call, and if the debt collector legitimately needs to find the person, in other words, they don't already have their location information, we've talked about that, home address, home phone, place of employment, then that call is probably okay. But if they start revealing details about, hey, this person owes money, or here's how much they owe, or I want their cell phone number, I want their email address, then that may have been over here where it starts to be legal, and now it's starting to cross the line to be illegal. And certainly from the neighbor's standpoint, if these calls keep coming over and over, and especially if you say, hey, look, stop calling me, I told you I'd give the message or whatever it is, then the neighbor may have the right to sue. But now the person that they were trying to collect against, they may have the right to sue the debt collector if the debt collector said things like, hey, will you take a note and then pass this message along? Because that's illegal to ask to do that. And if I'm the neighbor and I keep getting these calls and they're harassing me, I may can sue, and the person they're trying to collect against may can sue. So the bottom line is, when a debt collector is calling neighbors, it almost always crosses that line into being an illegal call under the FDCPA, the Fair Debt Collection Practices Act. So whether you're the person getting the call or your neighbor's knocking on your door, handing you a message saying, hey, I'm getting all these calls, you need to look at that very seriously, because most likely the debt collector is breaking the law. And you can sue for money damages, which has a wonderful effect of making them stop doing this. So if we can help you with that, if you live in Alabama, 205-879-2447. Be glad to help you. Okay, our next question is, how easy is it to beat Velocity? Because they're suing me on an old car loan. So it's a great question, and we've covered this in other videos, but typically when Velocity is suing on a car loan, we're talking about a 4-year statute of limitation. Again, as we've talked about in other videos, when does that 4 years begin? Well, it's going to be when we stop making payments, and typically it's going to be about the date of the repossession, and then you go forward 4 years. So I'm recording this on, June 9th, 2017. So if my car was repossessed on, let's say, February of 2013, and they're suing me. They filed the lawsuit June 2017. Well, that's too late, right? Because we start off 2013, go forward 4 years, and this is more than 4 years. So if that's the situation, then we have a good statute of limitation defense. Now, as with any collection lawsuit, you have a number of options. And I won't go over these in detail, but you have 5 options. You can file bankruptcy. Pretty rare that that's appropriate, but sometimes it is. You can fight this on your own, and that can often be a good idea. You can settle it on your own. You can hire a lawyer to fight it, or hire a lawyer to settle it. So those are the basic 5 options. Now, how easy is it to beat them on statute of limitation? Well, you have to know the law. You have to be familiar with the arguments that'll be made, because they're going to come in and go, that's absurd. It's not 4 years, it's 6 years. And they're going to start citing all these cases and the UCC, Uniform Commercial Code, and you have to be prepared to deal with it. But it's doable. Now, from an attorney standpoint, if we know what we're doing, we can pretty easily defend that case on statute of limitation basis. But what if we don't have statute of limitation? Well, we can still defend that case because you didn't borrow any money from Velocity. So you have the original creditor, they would have sold it to somebody, probably sold it to Santander supposedly, probably then supposedly sold it to Cascade, and then supposedly sold it to Velocity. Well, there's a whole lot of supposedly in there, and they've got to trace that title through to prove that they, Velocity, are the right ones to be suing you. If they can't do that, it would be like me suing you for not paying your rent. Well, unless I'm your landlord, unless I own the building you live in or the house you live in, I got no right to sue you. So Velocity, those are very winnable cases. Now, certainly anytime somebody goes to trial, somebody's going to win, somebody's going to lose. You could lose, whether you do it on your own or with a lawyer. But definitely you have a decent chance of winning those cases in Alabama. So if you're dealing with this in Alabama, just give us a call, 205-879-2447. Be glad to help you. Okay, our next to last question, this is also about Velocity, is I received a letter from Global, and I'm not sure the full name of that, I just don't recall, but it's a collection agency that works for Velocity. Got a letter from Global saying they were collecting on a Velocity debt, and the last payment was in 2007. So basically, this comes down to a statute of limitation issue, and then we'll talk about the Fair Debt Collection Practices Act. Velocity in Alabama typically is collecting on old car loans, 4-year statute of limitation. So if the date of last payment's in 2007, they should have sued us by 2011. So they are way late on that. Now, sometimes Velocity collects on, it might be an old credit card debt. The best case for Velocity is they have 6 years to do that. Well, 2007, 6 years, 2013, here we are in 2017, they got a problem. So they can't sue us, but what they may be trying to do is to get us to make even the smallest payment. They'll say on the phone, can't you pay us $5, $20? Well, once you do that, whether right or wrong, boom, they'll argue they restarted the statute of limitation. And now they have another 4 years or 6 years to sue you. So you have to be very, very careful about that. So another part of the question is, or at least implied in the question is this legal for them to do this on a debt that's like 10 years old? Is it legal? Well, I'll say this. It may technically be possible if they are incredibly careful to sort of navigate their way through the minefield to collect on a debt that's too old to credit report, too old to sue on, but it's very, very rare. So if they ask for a payment, they really need to be telling us in the letter, by the way, if you make a payment, we may then sue you because we may take the position, boom, you restart statute of limitation. Well, you can imagine they don't tell you that. So now they're being deceptive because they're presenting this, hey, you owe this and you need to pay us, but they're not telling you that you're about to make this terrible mistake legally if you do this. And certainly if they imply or they say something like, we may credit report, we may sue you. No, there's no may about credit reporting. There's no may about suing. They absolutely cannot sue you for this. They cannot credit report on this. It's way too old. So I'll say this. If you're getting a collection letter from something that's more than 6, more than 7 years old, then it is, I won't say 100%, but it's like 98% likely that they have violated the Fair Debt Collection Practices Act, and you can sue on that. Now, if you made a recent payment, within that 4 years or 6 years, that's a different story. But if you've made no payment, and we're talking about something that's 6, 7, 8, 9, 10 years old, then they've got a real problem collecting on that. They have to be incredibly careful. Now, some of the companies, they'll put on the letter, this is too old to credit report. Credit report's about 7 years. This is too old to sue. Okay, if they do that, now maybe they've navigated that. But again, I think they have to tell you, and by the way, if you make a payment, then we're going to be entitled to sue you. And they typically won't do that. So if you get an old collection letter, let us take a look at that if you're in Alabama. 205-879-2447. Just be very, very careful about any type of collection on these really, really old debts, because it's probably illegal what they're doing, and they may be trying to trick you into, like I said, you pay $5, $20, and then they come back and sue you. Okay, so our last question, and this is another velocity question. I have a velocity debt from 2007. It's too late for them to sue me. Don't they have to tell me it's too late? Well, it's similar to the last question. If you have a debt and Velocity claims to own it, that's a big claim, they have to prove that. But if they claim to own it and the last payment was in 2007, I'm assuming that's what this question means, then it's too late to sue in Alabama. It's too late to credit report. So do they have to tell you it's too late? I believe they do, because they will take the position, if you make this small payment, that then the restart statute of limitation, they can sue you. Okay, so here's a couple ways this can happen. One, they can say, they just are sort of silent about it. They don't say it's too late to sue, it's too late to credit report. They just say, this is a debt, this is legally owed. Well, no, that's getting them into some trouble when they say that. Or if they say, we may sue you, we may credit report. No, there's no may about it. It's too late to do that. Now, what if they say on the letter, this is too late to sue, too old to sue? Well, then we would need to know, if you made a payment, would they then turn around and sue you? Because I think that's deceptive, what we call a suppression of a material fact. In other words, something really important, and you need to know this, but they hide that from you. What if they say, we may use all legally enforceable means of collecting this debt, up to and including suing you? Well, now that's clearly illegal that they say that. What if they say, we may use all methods of collection? Well, let's see. All methods of collection. Credit reporting is collection, but they can't do that. It's too late. Suing you is collection, but they can't do that because it's too late. So if they start using that kind of language, all methods of collection, then I think they violate the law. And as I said in the last question, typically when you're getting these really old debts, there's like a tiny percent chance that they're not breaking the law. But almost certainly when these old debts come back all these years later, and then you get this letter or you start getting these phone calls, they're breaking the law. So my advice is get with a lawyer. Again, if you're in Alabama, just give us a call, 205-879-2447, and we'll be happy to help you think through this. So appreciate you watching this video. Hope these questions and the answers are helpful. Again, we're not able to give the complete answer to every situation because there's so many little specific details that matter, but hopefully this gives you a good start. And if we can kind of get you here, and then you can just build your way up to the answer. And the best way to do that is get with a lawyer in your state. If you're in Alabama, that's 205-879-2447. We'll be glad to help you run through your options, talk to you about the good, the bad, all the options you have, all the choices, and kind of the pros and cons of each one of those. And it's our pleasure to do that. hope you enjoyed this video, and feel free to keep the questions coming, and we'll do this again. Okay, thanks. Bye-bye.